Hello, everyone. Welcome. How's everyone doing tonight? Good. My name is Alexia Vanafra, and I'm a board member for Vermont Freedom to Marry. I'm also an attorney at Lang Roxbury & Wool in Burlington. On behalf of Vermont Freedom to Marry, we are absolutely delighted that so many folks came out tonight. And in fact, we'd like to start by going around and seeing who's around. So if we could start with Brattleboro. Could we see Brattleboro? Hi, Brattleboro. And we actually have the pleasure tonight of having a Vermont Freedom to Marry volunteer or board member at every location. So for Brattleboro, Barry is your volunteer. And Barry, could you just identify yourself?
I'm Barry Shamus.
Just say.
You can't see me?
Thank you.
Yeah. Hello, everybody. I'm Barry Shamus. I'll sit down.
Thank you so much for being there, Barry.
You're welcome.
And how about White River Junction? Can we see White River Junction?
This is Diane in White River Junction. Hi, everyone.
Hi, Diane. So Diane Fuchs is one of our board members, and she'll be your point person in White River Junction tonight. Thanks, Diane.
You bet.
And then can we see Montpelier?
Can we? I don't know.
Hi, Montpelier. And Cass is our volunteer in Montpelier. Can you identify yourself?
Hi, I'm Cassandra.
Thanks for being there, Cassandra. And here in Williston, can we see Williston?
I can't see the TV.
And our volunteer in Williston is Vermont Freedom to Marry board member Robin Friedner McGuire. Robin, can you identify yourself? We are also delighted that Ken Nussbaum has agreed to co-present with me tonight.
Hi.
Vermont Freedom to Marry has fought hard over the past 16 years to bring marriage equality to Vermont. And we were founded in 1995 with that mission. And we're happy to report that with the support of many supporters, volunteers, legislators, we actually succeeded. In 2000, we enacted civil unions, and in 2009, we were the first state to successfully legislate marriage equality rather than having it come down from the courts. Now, that being said, our work isn't done. While Vermont as a state has achieved marriage equality, that's not the case for 44 other states, and it's not the case for our federal government. And what that means is if you are married, whether you get the same benefits and protections that other married couples do really depends on where you happen to be standing or who you happen to be talking to. So if you're talking to federal entities like Social Security or the IRS, you and your spouse are legally unconnected or friends, essentially, as far as they're concerned. And that is the case in most other states in our country as well. In many instances, until we repeal discriminatory laws like the Defense of Marriage Act at the federal level, also known as DOMA, there isn't a whole lot we can do to prevent this discrimination, which is why we as an organization have refocused our goals on three things. One is to repeal DOMA at the federal level. Two is to help our sister states achieve marriage equality and maintain marriage equality, as we're seeing some of our friends are struggling with. And three, in the meantime, while we don't have equality everywhere, we want to be the resource and continue to be the resource for Vermonters and make sure that they have the information and the resources that they need to keep their families and themselves safe. So, whether you're married, in a civil union, in a long-term relationship, or whether you plan at some point to be in a same-sex relationship, Ken and I are going to share some information tonight for you to consider. But before we go into that, please keep in mind that what tonight is going to be is an overview of issues to watch out for. There is no one-size-fits-all planning strategy. So what we can't do for you tonight is to give you specific tax or legal information on your situation. But what we can do is expose you to a broad variety of issues, some of which are bound to apply to you and your family personally, so that you can leave tonight with hopefully more information that you had before you came, and maybe with some ideas about next steps to take. So, with that, I will get started with my piece, which is the legal piece. I want to thank folks in advance who sent questions in advance. We had put out a request for that. The way that I'm going to handle that, I'm going to cover some of those in my initial presentation, and then some of them at our question and answer period, and I think Ken's probably going to do the same. We're each going to speak for a little bit, and then we really want to open it up for a question and answer period so that we can get your questions answered.
That too.
That too. Your answers, questions. And we will question your answers.
Question my answers.
Exactly. Things that you can put into place, some legal things that you can put into place to protect yourself and your family. Number one, an advance directive. An advance directive, also known as a health care proxy, is a document where you can name your spouse, your partner, your loved one as your agent, as the person to make medical decisions on your behalf if you can't do so. Having this is critical because you, as spouses, if you are married, are not going to be recognized as spouses in most states. The moment that you travel outside of Vermont, you are risking being hospitalized and being denied, one of you being hospitalized and the other one of you being denied visitation, the opportunity to obtain critical medical information, and the opportunity to make medical decisions for your loved one. That's where this advance directive comes into place. If you write out this advance directive and you execute it, then basically you are giving whomever, be it your spouse or your friend, that power. And so it's an important document. It's free. You don't have to go to a lawyer to do this. You can Google Vermont Advance Directive, or if you've received the handouts that we're bringing out tonight, and I apologize, I forgot to mention to the greeters, if you haven't handed them out, if you wouldn't mind going ahead and handing them out, I'd appreciate that. In your handout in front of you, you actually have a link that you can go to download that advance directive and fill it out. So that's number one. Number two, regardless of how large or small your assets are, having some documents in place like a will and or a trust that dispose of your property at death the way you want it to be disposed of, and that nominates a guardian for any minor children that you have, is also important. And along with that, a financial power of attorney, which names somebody to make financial decisions and financial transactions on your behalf when you are alive, in situations when you can't do so. You're out of the country or you're incapacitated, for example. So those are three documents, 3/4 documents that you can put into place. The next three things that I want to talk about are for folks who have kids or plan on having kids. One question that I received was from a non-biological parent, and she asked, I am married to my children's natural parent. I'm on the child's birth certificate already. Do I still need to have a second parent adoption? And the answer is absolutely yes. Without a doubt, yes. I'm going to speak about my own situation. My wife and I have a son, Jake. Jess, my wife, carried Jake. I don't have a biological connection to my son. Now, we're married, and as far as Vermont is concerned, that's good enough. Vermont recognizes me as Jake's legal parent, but that is not the case for the feds, and it is not the case for most other states. So I adopted him, because had I not adopted my son, Jake, if I were to die when he's still a minor, the Social Security survivor benefits that children are entitled to, Jake would not get, because as far as the feds are concerned, he's not my son, but for the fact that I adopted him. That's the only reason why the feds think he's my son. Okay? Had I not adopted Jake, I wouldn't have been able to take leave under the Federal Family Medical Leave Act when he was an infant to stay at home with him. And had I not adopted Jake, were Jake ever to fall ill as a minor, I wouldn't get to take advantage of that same act to stay at home with him and take care of him. So those are just a couple of examples about why you need a second parent adoption. So if you take nothing away from tonight, please, please, if you are a parent that is not if you're a parent that is not biologically connected to your children, please get a second parent adoption as soon as you can so that the federal government and all states can recognize that important parent-child relationship from which benefits flow. Also, if you plan on having children, there are things that you can do to put into place for that protect the non-biological parents' rights until the adoption is finalized. For example, ladies, if you plan on using a known sperm donor, you would want to put a donor agreement into place before you start trying to get pregnant. And gentlemen, similarly, if you are thinking about surrogacy, you would want to put a surrogacy agreement into place. Okay. So those are 6 legal things that you can do to get some, not all, but some of the benefits and protections that are automatically afforded to other couples. And again, the list is advance directive, will and or trust, financial power of attorney, adoption, donor agreement, and surrogacy agreement. Okay. Now, I want to cover just a couple more issues that same-sex couples face that other married couples do not. With these issues, there is no magic document that I or an attorney could draft for you to get you, to put you in the same situation as federally recognized spouses. These are the kind of issues that until DOMA is repealed, frankly, there isn't a workaround. But they're important for you to know them for a couple reasons. One, you need to know that you're going to be treated differently. And 2, it's important for the professionals that you work with, your attorney, your accountant, and your financial planner, and other professionals that you work with, to know about these, because sometimes, even though there isn't a specific workaround around that particular issue, if we look at the issue globally, we might be able to compensate for it in another way, not necessarily with that particular thing. I hope that made sense. The first thing that I want to talk to you about are estate and gift taxes. The estate tax is the tax that you have to pay on all the assets that you own at your death. I'm not going to cover this except to tell you this. If you die in 2012 and you have assets that are $5 million or less, you're not going to owe any estate taxes. Okay? That's your tax-free amount for 2012 is $5 million. In 2013, that tax-free amount goes down to $1 million, unless Congress acts, and your guess is as good as mine what Congress is going to do about anything. So if you are someone who is worried about, and by the way, those are federal taxes. There are also Vermont taxes at a much lower rate. But if what I just said makes you concerned that you might be exposed to estate taxes, it's important for you to talk to an estate planning attorney about your particular situation. I'm going to move on to the gift tax because the gift tax is something that concerns all of us regardless of the size of our assets. Generally speaking, this is the rule about gift taxes. If you make a gift to someone, you owe taxes on that gift. If you make a gift to someone, you owe taxes on that gift. Or at the very least, you're going to have to report that gift to the IRS. Okay. Obviously, there are exceptions to that rule. The last thing the IRS wants is for you to run and file a piece of paper every time you buy somebody a Christmas present, a Hanukkah present, or a birthday present, okay? So there are some big exceptions, and the 2 that I just want to highlight for you tonight are these. The first one's called the annual exclusion. And what the annual exclusion says is if I give a person $13,000 or less, I don't have to report it to the IRS, and I'm not going to owe any taxes on it. Okay? And that's called the annual exclusion. So if this year, in 2012, I give Ken $13,000 and Robin $13,000 and Gwen $13,000, Madison wants $13,000, and Ewan wants $13,000, and Ernie, I'm sure, would take $13,000. I can make all of those gifts, and I don't have to do a single bit of reporting, and I don't owe a dime of taxes, because to each individual, I only gave $13,000 or less. Okay? So that's the annual exclusion. The other big exception is called the marital deduction. And what the marital deduction says is you can give as much money as you want, as often as you want to your spouse. And you don't have to report it, and you don't have to pay taxes on it. Now, this is federal law, and therefore a spouse is defined as one man and one woman. Okay? So, let's take my imaginary opposite sex couple, John and Emma. John loves Emma. John's got a lot of money. John decides that he wants to give Emma $13 million just because she's so sweet. And he does. In 1 year, in 1 day, he writes her a nice big fat check, and he gives her, did I say 3 or 13? 3? 3. He gives her $3 million. He doesn't have to report. He doesn't owe taxes. He can give her $13 million. He can give her $100 million. And he doesn't have to report, and he doesn't have to pay taxes because it's his wife. Okay? Now let's say John is married to Evan instead, and he wants to give Evan $3 million because Evan is so sweet. Well, Evan is not his spouse according to the feds. They do not qualify for the marital deduction. The only thing they qualify for, as Evan, as John's friend, gets is the $13,000 annual exclusion. So any gift above that $13,000 has to be reported at the very least and may acquire gift taxes. And remember, when I'm talking to you about gifts, I'm not talking about just gifts of cash. I'm saying you buy somebody a new car, or you give them stock, or you decide to put your honey on your deed to your house. Which leads me to our next topic, which is real estate transfers. Say John owned a house before he married Emma. We're back to Emma now. He owned a $300,000 house. Now they're married. Now they're living in the house. And he says, well, I want to put Emma on the deed. You know, we're married. We live here. Let's own this property jointly. He does that. Not a problem. The marital deduction says you can give your spouse as much as you want. He doesn't have to report it. He doesn't owe any taxes. Same scenario, but John is married to Evan. The gift is more than $13,000. So that means that you have to report it, and John may owe taxes on it. So the reason why I'm spending time on this is because this is very common. It's common for us to put our loved ones, to put our spouse, our partner, our long-term partner on our property. And the thing is in 2010, the IRS actually launched a compliance initiative seeking out people who are doing this. They're not specifically looking out for same-sex couples. They're just going through property records, through land records, looking at transfers of property like this, and auditing people who have made these kinds of transfers and haven't filed a gift tax. So I just wanted to raise that for you. Another possible negative consequence of putting your loved one on your deed, including them, having them own your house jointly, is if you still have a mortgage on your house, then the mortgage will probably have a little clause that's called a due on sale provision. And what that clause says is, let's say I owned a house before I married Jess, so not true, but I owned a house before I married Jess. And then we get married, and I'm like, oh, okay, honey, I'm going to put you on my deed, but I still have a mortgage on it. The due on sale provision says, Alexia, if you transfer this property to anyone other than your spouse, then we, the bank, can come after you, and you're going to owe us the entire amount that you owe on your mortgage next month. That's what the due on sale provision is. And because that is federal banking law, the spouse is defined as one man and one woman, and therefore just wouldn't qualify as my spouse. And that could happen. That's the bad news. Um, the one thing that same-sex couples and same-sex married couples and civil union partners and opposite-sex married couples can obviously do is to hold property as tenants by the entirety. Okay, in Vermont we have this thing called tenants by the entirety. Typically, we're talking about couples owning land jointly, and there are two ways in Vermont to own land jointly. You can own it as joint tenants or joint tenants with rights of survivorship, maybe you've heard, that's the long name for it. But you can also own it as tenants by the entirety. And both of these, joint tenants and tenants by the entirety, they both give each owner a 100% undivided interest in the property. So it's the same thing that way. The thing about tenants by the entirety is that there's an extra layer that says one owner can't transfer their interest in the property without the other owner's permission. Why is that important? Take Jess and I again. We own our home together. Say I accidentally hurt somebody. I run somebody over, they sue me, and they get a big judgment against me. They get a $500,000 judgment against me for the pain I've caused them. If Jess and I owned our house as joint tenants, then that person could come after our house and take our house from us to satisfy that judgment. But if we own our house as tenants by the entirety, which we do, that person that I hurt would have to get Jess's permission before they took our house. And those of you that know Jess know that she's nice, but she ain't that nice. So it's a really good added layer of protection, and all it takes is for you to go home, take a look at your deed, see if you own it as tenants by the entirety, and if you don't, just get a new deed redone. Okay, because it's worth it. And again, this is something that's available only to married spouses, any married spouse, because this is Vermont law, same-sex or otherwise, and civil union partners. Okay. So, last thing I want to talk to you about before I turn it over to Ken is our retirement benefits. I had somebody ask me the following question. If a same-sex spouse dies and I'm going to try that one again. What happens if a same-sex spouse dies and her spouse is a beneficiary of her IRA? Can the surviving spouse roll over the IRA into her own IRA, or is she forced to start taking distributions immediately? All right, so I'm going to talk about a couple scenarios to explain that question and give you an answer. But before I do, here's my disclaimer. You know how lawyers love disclaimers. Retirement assets in particular are very, very specific. They're fact specific and they're plan specific. So what I'm talking to you about right now is general stuff. But if you have questions about your retirement plan, talk to a tax professional. So let's take John and Emma again, our federally recognized spouses. John has his wife, Emma, as his beneficiary on his IRA. Even if John had begun withdrawing from his IRA before he died, at John's death, Emma can roll over his IRA into her own IRA. And what that means is that Emma doesn't have to start withdrawing on that IRA until her required minimum date, which is typically 70 and a half. Let's just say 70 and a half for tonight, okay? So, and at 70 and a half, she'll have to start taking distributions, but those distributions will be a lot smaller. The mandatory distributions will be a lot smaller than they would have been had she not done this rollover thing. Now, the reason why that's important is assets in an IRA, in a traditional IRA, are not taxed. You get them from your employer and they stick them in this account before you ever pay any taxes. So they're tax deferred assets, and they get to hopefully grow, although we never know in this economy, but hopefully they get to grow tax free. And so the longer you don't touch them, then hopefully the bigger they grow. And that's why giving her a chance to defer when she has to withdraw is a good thing tax wise. That doesn't mean she can't. She can withdraw at a certain age if she wants to, but we're talking about giving her an option to really stretch that out if she wants to. So Emma can do it. She can roll it over into her IRA, and she doesn't have to start withdrawing till she's 70 and a half, and then those minimum required withdrawals are small. Okay? Now let's say that John is married to Evan instead. Even if John dies before he starts withdrawing from his IRA, Evan cannot roll John's IRA into his own IRA. No matter what, Evan cannot roll it over into his own IRA. He's going to have to start taking the minimum requirements almost immediately. And those minimum requirements are going to be larger than what Emma would take out. And when you take it out, you have to pay income taxes on whatever you take out. So to answer the question, no, a surviving spouse, if it's a same-sex spouse, cannot roll it over, and she will be forced to start taking distributions practically immediately. And again, I'm talking about traditional IRAs, not Roth IRAs, because Roth IRAs, you've paid taxes on them before you stick it into the Roth, and therefore pretty much the feds don't care what you do. And Ken will be way more specific about that. General. What about 401ks? Say John had a 401k instead of an IRA. Well, then Emma would have absolutely been able to roll it over just like she did with John's IRA. And Evan, there's actually a possibility that he'll be able to roll it over into his own IRA, but that is very, very plan specific. So if that's your situation, go talk to a tax professional. And finally, what about Social Security survivor benefits? At John's death, Emma, as his spouse, would be entitled to John's Social Security survivor benefits, essentially the retirement benefits that he was collecting and he would have continued to collect had he not died. In addition, any minor children of John's would also get some additional Social Security survivor benefits. So that would be the case for John and Emma. However, in that same scenario, if it's John and Evan, Evan would not receive any Social Security survivor benefits whatsoever. And the only chance for the family to see any of that money would be if John had minor children who could receive the Social Security survivor benefits. But as I mentioned before, in order to be considered John's children, they have to be considered his legal children. In other words, they either have to have a biological connection to John or John had to have adopted them, which is, again, why adoptions are so important. So those are the topics that I wanted to cover, and now I will turn it over to Ken.
Great. All right. There I am. All right. Well, we've seen plenty of examples so far of how the laws work against same-sex couples. And as we shift to income tax issues, what I'm going to try to do is give a few examples of how, within the context of DOMA, which is, at least for now, the law, we can do some planning that can work to the benefit of same-sex couples. And this, by the way, is a very specific, a very specialized area. So if you're working with a tax professional, make sure that they understand the specific issues that are, and the specific opportunities that are available. Because I've seen, as we'll go through, I've seen examples of people that either didn't really pay attention or didn't understand the circumstances. So, again, we're going to talk about some advantages that we can take with the tax laws. And as Alexia mentioned before, the objective is to spread awareness. Okay? This is not intended to be a graduate level tax course. All right? There will be things that we talk about this evening, as Alexia mentioned, that are very general in nature. We're not going to go into the, oh, but I heard that there's this little narrow exception that if you stand on your left foot for 14 minutes, you can do this instead of that. We're not going to talk about those. I'm going to talk, as I say, mostly about income tax issues. I'm going to get into just a little bit of gifting, a little bit more than what Alexia mentioned, and then also just a very brief bit of estate planning. Each of these topics, by the way, could be the subject of its own seminar, and trust me, you wouldn't want to go to the seminar next week where it's going to be a week-long estate planning conference that I'm attending. You wouldn't want to do that. As you're thinking about questions that you may have for us, I can tell you that I already know the answer that I will give to any question that somebody asks me. Many of you may also know the answer, and that is, it depends. Again, this is all very fact-specific, very circumstance-specific. So as we go through these issues, bear in mind that these are for illustrative purposes only, okay? So income tax. As we know, same-sex marriages are not recognized federally, at least not yet. Same-sex couples, however, can file Vermont income tax returns as a couple, not as two individual people as they have to on the federal level. So what that means typically is that just doing the income tax returns for same-sex couples tends to be more expensive just because there's more involved. There's more from an administrative level of keeping track of what we need to do and how do we balance this and how do we do that. And if you've had the pleasure of going through that process as opposed to just working with a professional and letting them handle the fun, you know it can be not so much fun. So I want to focus, though, on the positive, not on the negative. And I'm going to share some examples of things that I've experienced with my client base and that hopefully you can take as, oh, wow, that may apply to me, or, maybe we can do this. And I apologize in advance for those of you who say, well, gee, you didn't talk about anything that applies to me. And I'm also going to give a disclaimer. As they say in the movies and in TV, the characters appearing in this work are fictitious. Any resemblance to real persons, living or dead, is purely coincidental. All right. So what I want to talk about is a few specific areas, and again, I know I'm not going to cover that one area that you really wanted to hear about, so I apologize in advance. We're going to talk about filing status, we're going to talk about dependency issues, and we're going to talk about deductions. Filing status. So, excuse me. We're going to start with Susan and Lisa. Susan and Lisa are a married couple, and they have 3 children. Susan happens to make significantly more income than does Lisa. When they came to me, I looked over the prior returns that they had done. I noticed that for reasons that I didn't necessarily, that weren't readily apparent to me, Lisa was filed as, Lisa's filing status was head of household. Susan's filing status was single. And in looking at that, again, it was one of those things where we're not going to go into what does head of household mean, what does single mean. Very, very briefly, though, head of household would be appropriate for somebody who is responsible financially for more than 50% of maintaining the household expenses. Again, very general explanation. So in the case of Susan and Lisa, I asked some questions, and it turned out that, as I suspected, that Susan was really the one that was providing the bulk of the household expenses. So when I said, well, is there a reason that Susan's filing status was single and Lisa's filing status was head of household, thinking, there may have been some philosophical reason that they wanted to do things one way or another. And they looked at me and they said, no, that's what our prior tax guy did. And so, again, I was just asking questions, and the gentleman or the individual that was doing the return before, there may have been some reasons that made sense at the time, and I don't know. The bottom line is that we went back and amended the returns, and again, results not typical. We went back and amended the returns for Susan and Lisa for the prior 3 years, which we were allowed to do, and in their case, the net benefit to them was about $8,000. Not to mention the fact that going forward now, the years we've been working together, we've done things the same way. and again, got those benefits. So let's talk now about dependency issues, all right? This is a couple, John and Ted, and John's sister had just graduated from college and didn't have a job and lived with them for an entire calendar year. And again, they came to me, and important piece of information, had no income. She didn't have a job. She was looking for a job while she was, in school and then after school, but she had no income. So, again, in this case, there was a disparity in income. Ted's income happened to be fairly, pretty much a lot more, I should say, significant than John's. And when I looked over the prior year returns, same type of question came up. John, why are you claiming Maddie as your dependent? I don't know. That's what they did, whoever they are. So asked some questions, got some more information, and it was clear that it was appropriate, given the facts and the circumstances, that in that particular case, Ted was eligible, allowed to take Maddie as a dependent. Went back, amended those returns, and in that case, it was only about $1,000 net benefit, but still, it's something. All right, so another question that I get typically is, what about deductions? And in the usual case, it has to do with the interest or real estate taxes on a home. And as Alexia mentioned, for whether you've got the deed, or whether you own the home or your spouse owns the home, before you've done the deed transfer, there may be some interest on the mortgage if you have one, and of course there will be real estate taxes. So again, very fact specific, but depending on the circumstances, it may work to the benefit, and it may be perfectly allowable for one spouse, one partner, to take the deduction as opposed to splitting the deduction, or as opposed to having the other spouse take it. So in general terms, okay, few different scenarios that I've seen. One is one spouse is the owner of the home and is liable on the mortgage. The other spouse is not on the deed, doesn't have anything to do with the mortgage. In that case, generally speaking, it's pretty straightforward. That spouse would take the deduction. I've seen situations where they're both on the deed and only one is on the mortgage. Again, in that case, depending on the facts and circumstances, in that case, I'm pretty comfortable with the one spouse that's on the mortgage taking the mortgage deduction. All right? Then, of course, there's a situation where both spouses are on both the deed and the mortgage. Well, that gets a lot more complicated, and that, you ask, how do you split it? Well, you already know the answer because I gave you the answer to every question that's going to be asked, and that is, it depends. So that's one of those where it's very fact-specific, and I've seen it go, well, can't really do anything other than split it down the middle. I've seen it go, yeah, because of this circumstance, I'm comfortable with it all going one direction or the other. Bottom line is, be aware that these are possibilities, all right? Another very typical question that I get, and one that I love getting here at the beginning of the year as opposed to at the end of the year and say, gee, what should we have done? And that has to do with charitable deductions. Again, this I've seen typically work better in circumstance where there is a fair disparity in income between the spouses, but doesn't necessarily have to be. If one spouse itemizes deductions and one spouse does not, then what you can do, again, ahead of time is even better, but what you can do is you can say, all right, well, I'm going to let you make all the charitable contributions out of your checking account or from your pocket, because if I'm not itemizing deductions, there's no benefit to me. You're itemizing deductions, you're going to get the benefit. So, okay. a little bit more esoteric example that I'm going to give. And again, it has to do with a situation where there is a fair disparity in income. And it is a great example of, okay, federal law, you say I can't file with my spouse on a joint income tax return, so I'm not going to. I can't. You're not letting me. Oh, but by the way, what I'm going to do is take advantage of the tax laws. And there's something called the Earned Income Credit. And I'm not going to go into the details of the Earned Income Credit, but I want you to listen to the scenario, and if it fits you, then definitely make sure that you either already have been taking advantage of it or figure out what you can do to take advantage of it. So, again, this is one of those caveats, very fact-specific. But let's go back to our friends Susan and Lisa, okay? I already mentioned that Susan had significantly more income. I think it was Susan who had significantly more income. These are fictitious people, so it's hard to remember. So Susan had significantly more income than did Lisa. But Lisa did not have no income. Lisa did have some income. And again, because of their situation with having more than, or having children and all the other stars that aligned to help them in this case, when we filed the tax return for, when we filed the tax return for Lisa, we realized that we were able to take advantage of this earned income credit. And again, without going into details of what it does or how you get to it, tell you what it does. What it did for them in this case was Lisa was eligible for, on her income of about $10,000, somewhere in that range, she was eligible for a tax credit, meaning money in her pocket, of about $3,000. Okay? And if the federal government had recognized their marriage, they wouldn't be eligible for that. So again, it's one of those, is there a philosophical objection to this? And the answer was a resounding no. One important caveat, okay, because I mentioned I'm not going to go into the details of the earned income credit. But in their particular situation, this was an issue. The earned income credit has a cliff where if you have more than a certain amount of investment income, which for 2011 it was $3,150. I don't know exactly what it is for 2012 yet. However, Lisa was very close to that, okay? And what we needed to do was coordinate with Lisa's investment advisor, who was not aware and had no reason to be aware that Lisa would be eligible for this earned income credit, but explain how it worked and why, if Lisa's investment income yielded $3,149, she was okay. If it was $3,151, she would lose out on this tremendous benefit. And again, the benefit varies year by year. So, all right, have I got your attention yet? I wish that I could say that all of these things that I've mentioned would apply to everybody that's listening, everybody that's out there. It's not the case. The bottom line is that there's a lot of arrows in the quiver, and it's just using the appropriate one for the appropriate situation. One thing I want to mention as a sort of a reminder is that because you're allowed to file in Vermont, you're allowed to file a joint return, but you're not on the federal level. I've had situations where people said to me, clients, new people that have been referred to me, said, oh, well, I don't file a joint return because I'm the only one that has income, all right? So in this particular case, Mark and Al, Mark was retired, didn't have any income, minimal Social Security, whatever it may have been, and Al was not retired. He had his income, and he said, well, I'm the only one that's working, so I just file a married separate return, and that's about the worst thing that you could do in Vermont, because you're just throwing money away, all right? The way that it works, especially if one spouse does not have income or doesn't have any significant income, you're losing out on a tremendous benefit. So again, without going into the detail and without you getting a doctorate in tax law, that's the gist of it. In their case, by the way, just because I had to throw out the number, it translated to about $2,000 that we were able to get back from them for them over the 3-year period. So I want to put this overhead up here, and if Devin can throw that, now look at that. All right, hopefully you can see it okay. This is a W-2, and I've highlighted a couple of boxes, which I don't know if we can see. Oh, it's in the back here? It's not up? Okay, sorry. So another thing of which I want you to be aware, especially those of you who get partner benefits or spouse benefits for health insurance, okay? You may not realize that the W-2 is going to have a different number, or at least should, ideally, have a different number on the taxable wages for the federal line and the Vermont line. We know that, unfortunately, until DOMA is no longer the law, the benefits for your spouse are taxed for federal purposes. They're not taxed for Vermont purposes. Okay? So make sure you're aware of that, and when you file your return, make sure that you pick up the right number on the Vermont tax return. So if it's not, and we can get off the overhead now, Devin. Thank you. Ooh, caught me in mid water. All right. So if it's not already apparent, these are not issues that are just run-of-the-mill. These are very fact-specific. These are things that, again, I hope they apply to you. I hope that you are already aware of them and have already been taking advantage of them. If not, then please seek guidance if something has resonated with you. And what I want to do is now just very quickly cover another very tricky area. And Alexia mentioned some of the estate and gift issues. I just want to touch base on a couple of them, repeat a couple of things that she said, and then add to a couple of things. Now, Alexia mentioned the fact that I can give my wife as much as I want during the year, and there are some, again, there's some of those little asterisks. Well, but I heard if the spouse is not a U.S. citizen, there's different rules. Okay, you got me, but we're not talking about that tonight. But Jess can't give Alexia whatever she may want to get without having these rules kick in. So the $13,000 a year, I just want to point out, that is the annual exclusion amount, as Alexia mentioned, but there are a couple of important additions to that, okay? One is medical expenses, and the other is tuition. Now, those expenses have to be paid directly to either the medical institution or the educational institution, but bear in mind that tuition does not have to be college tuition. If you have grammar school children that are going to a private school and you you don't make the income, your spouse can pay for your child, and if they haven't done the second party adoption, it's not their child legally from a federal perspective, but we can make those payments without running afoul of the gifting rules. And as Alexia mentioned, in 2012, there's this unique opportunity to gift. It's actually a little over $5 million because there was an inflation adjustment, but the point is that it's out there. All right. If you happen to be in that situation, or you know someone that is in that situation, we don't know what's going to happen after 2012, so it's definitely something that you're going to want to consider. All right. Now, I want to finish with just mentioning the fact that there is actually an estate planning opportunity for those of you that maybe say, well, that's nice, I can give $5.12 million to my husband or my wife, but I want to do more. What else can I do? There is a unique estate plan, and I'm not going to go into it, but I'm going to tell you the name of it, and if it applies to you, we can talk about it offline. There's a unique estate planning opportunity that is not available to me and my wife, but is available to Alexia and Jess, and that's something called a GRIT, all right? And basically, it stands for Grantor Retained Income Trust. And it's basically you as the spouse with the assets set up a trust, and the income from that trust, and then, well, the income from that trust flows out, and then after the stated period of the trust, and again, I actually already went into more detail than I intended, but once the stated period of the trust is done, anything left over goes to whomever you deem, your spouse, or whomever you deem as the beneficiary. So there you go. There's some good news in the land of the federal government when it comes to same-sex couples. And thank you very much. And I think at this point we open it up to questions.
We do. And the way that we're going to do it, just so that we can make sure that folks have a chance to ask questions, we are at
Lots and lots.
60, 70, 80, 85 people total in all these locations, which is wonderful. So what we're going to do is we're going to go around to each location, and we're going to give 2 people to get a chance to ask a question in Brattleboro, then we'll move to Montpelier, then White River, and then here, and we'll just keep going around and around. So that's one thing. The other thing is so that more folks can have a chance to ask questions, we would ask each individual to limit their question to 1 question at this point, and then if we're running, if there's silence, then feel free to to ask another one. But we also have some questions that folks have sent in. So with that, how about we go to Brattleboro?
Brattleboro, hello.
Hello, Brattleboro.
I've been wanting to say that all night.
Are there any folks in Brattleboro who have a question?
There's one.
Hello, can you hear us? Wave if you can hear us.
Hello?
Could we see Brattleboro, Devin, please?
As soon as they talk, you'll see them on the back.
Ah,
Aha.
can somebody say hi to us in Brattleboro
Hello?
so we can see
Can
you?
you hear me? Can you hear me?
Yes.
Hello. Okay.
Hi.
Hi, I'm Ron. Here's the question. Is there a database that's accessible, hopefully online, that would list same-sex friendly lawyers and financial advisors that we could access?
We at Vermont Freedom to Marry have put out a request for self-identified LGBT-friendly professionals to give us their information, and we will be putting that up on our website. We haven't done so yet, but that is one of our projects.
Would it cover New
again, and
Hampshire?
these are folks.
I'm sorry, would it cover
Pardon?
New Hampshire? Would it cover New Hampshire?
You know, I believe that what we have so far is only Vermont, but I couldn't tell you for certain, Ron.
Okay. Thank you.
Sure.
And actually, Ron, if I could just add, it's for the legal aspects, obviously you need a New Hampshire lawyer, but if you're talking tax aspects, you don't need to be limited to somebody in New Hampshire. I have clients all over the country, so. And the financial professionals, I would imagine it's the same answer.
Okay, thank you.
Next.
Is there anybody in Brattleboro that has a question? Anybody else?
I have a question. My name is Emily. Is a second parent adoption necessary if we use my eggs but she gets pregnant? So I would be the biological parent.
Yeah, it depends.
And if so, who would do the second parent adoption? Can we both do it to cover ourselves?
No, Vermont. Are you guys live in Vermont?
Yeah.
Yes. The thing is you have to look. It's very state specific, and I can't tell you off the top of my head what Vermont says about that. So I would say at the very least, talk to somebody and have them research that for you.
Okay.
Sorry, I can't give you a better answer.
Thank you.
Is there anybody in Montpelier who has a question?
I have one.
If somebody says hi from Montpelier, we'll be able to see you.
Hi, this is Deb from Montpelier.
Hi, Deb.
Hi, I have a question. We are just launching into the financial aid application for college, and there's the FAFSA, and there's this College Board forms, and they are they're a little tricky to navigate in terms of how we file. So we file head of household, each with one dependent child, and so it's just confusing to know if we should then use the recomputed form that we send in with the state, or whether we should just the one that claimed that child be filling. You know, I'm wondering if you have any advice, because we're just getting started with this work.
You know, somebody else, I'm glad you brought that up, because somebody else brought up a FAFSA question, and I'll be honest with you, I don't do work around FAFSA, and this is actually something that I want to open up to the audience to see if anyone has had what experience they've had. This is what I was able to find out online. Basically, if you are a same-sex couple, a married same-sex couple, and you have children, when it's time to fill out the FAFSA, they end up treating you the same way that they would treat a divorced opposite-sex couple, which means, isn't that beautiful? So what that means is they do some crazy formula, and they figure out which one of you is worth more, essentially, and then they pick that one of you to be the parent that financial aid is measured against. What I don't know, and what I'm curious about, is whether that changes if in a scenario where in your couple one of you is the biological legal parent and the other one of you has adopted the child, so according to the feds you're both legal parents. I'm wondering whether that changes, but I don't know, and I wasn't able to find anything in my research. So has anyone been in this situation that is willing to speak to the situation?
Well, just to add a little bit to that, layered on top of that issue is the fact that while for FAFSA the answer may be one thing, depending on the school, they may look at things a little differently. So that is one of those that, unfortunately, the answer is it is so fact-specific that it would be almost reckless to try to give you an answer specific to your situation without having more of the details. Sorry.
But has anyone who is there a non-biological parent out there who adopted their kiddo and applied for federal aid through the FAFSA that can talk to us about that experience if you're willing to?
Anyone? Bueller? Okay.
Is there another question in Montpelier?
Yes. Over here? Just speak into the mic. Okay. The question is, can you speak a little bit about the implications of using a joint checkbook and both partners contributing if one is earning a lot more than the other, and whether that gets into gift tax situation?
It depends, and I'm not saying that just to be rude, but typically in the situation that you're describing, you're not going to run into any major problems as long as it's a sharing of the household expenses. Where you could run into an issue is if one spouse or one partner is putting in all of the money and the other spouse or partner is taking out significant chunks and using it for, something not household related. That's about it, as general as I can, or as specific as I can get it without getting into more of the, very, very fact specific issues. Does that help?
It does.
Excellent.
Yes, thank you.
Mm-hmm.
How about we move to White River Junction? Is there anybody in White River Junction who has a question?
Apparently not.
I think we're going to pass from White River Junction. We're awfully quiet here today, but thank you.
Sure.
Speak up if you do have a question. You haven't lost the opportunity. Come on here.
And how about Williston? Robin? Gwen?
My partner is Robin. Hi, yeah. My question is, I'm the primary earner in the household, and my partner is on Social Security disability. And my tax filing status has still always been single. How does her income, how does Social Security disability income count in terms of me possibly being able to file as head of household?
Well, is it just the two of you?
Yes.
Okay, you wouldn't be able to file as head of household. What you may be able to do is claim her as your dependent.
Okay.
And that's going to, again, it just depends on what else is going on. But if the only income is Social Security, you probably won't be able to, even if the only income is Social Security, you probably won't be able to do that. But it depends on the specifics. Okay.
Thank you.
Regarding documents like the Advance Directive, Financial Powers of Attorney, that protect you when traveling elsewhere, do you recommend that you carry copies of all of these documents on your person anytime you leave the wonderful borders of Vermont?
Yes, and I know that's onerous, but I would recommend that. The thing about the Advance Directive is Vermont does this wonderful thing. They actually have a registry. And so what you have is you send away your Advance Directive, that form that I told you to print out. There's a little registration form that you send with it. And they upload it online, and they send back these cards with a code on it. And so you can give that code to your agent, to whoever you pick to be the person in charge, your primary, and then whoever you pick as your backup. And so doctors and hospitals can get into that system without any code. So depending on, who knows about it. In Vermont, they do it often. They can look up your information and look you up and say, okay, here's her Advance Directive. But the other thing is if you don't want to carry around the Advance Directive, what your agent can do, because you don't have to carry it around, it's not going to be you using it, but your agent can just keep that wallet card in their wallet so that they can just run online, enter in the password, and print it out when it's necessary. So that's the thing about the Advance Directive. And as far as your financial power of attorney, yes, the will and the trust isn't as important to carry with you at all times, but we carry around, personally, we don't carry around our financial power of attorney, but what I do travel with all the time is my adoption order for my son.
Sure.
Madison?
I have a follow-up question on that for paperwork. Clinton signed in 2000 the electronic signature thing, so electronic documents are real documents. It can be difficult carrying those documents around with you. Do you have to carry a copy? Is copy sufficient? If a copy is sufficient, would it be okay to upload those documents online so that you could retrieve them from anywhere?
Here's the thing. You don't know who you're going to be dealing with. Okay, so in these situations, sometimes it doesn't matter what the law is. And even if you travel around with these documents, the bad news is I can't guarantee you that it's going to work. Okay, so I've heard of tons of situations where somebody has walked into a bank with a financial power of attorney, the original, and the bank still won't do it just because they're plain dumb. So I don't know. I think that what looks most legitimate and what people understand the most are an original that has a seal on it or some important signature on it. But so I couldn't tell you one way or the other what's going to work or not, because it really depends on who you're dealing with at the time.
Yeah, and I would just add to that, because I've had situations where the electronic copy, no problem. And I've had situations where the, sealed document with, the judge saying, yep, I saw them, so, too bad. So, obviously, that's a bit of a artistic license, but the point is that you don't know. Or it depends.
Can I ask just one other question? That was just a follow-up.
Yep, that's fair. Go ahead.
My question is...
This is a Vermont Freedom to Marry board member, by the way.
Hello, everyone. My question goes back to gifts, again, and that whole joint sharing of accounts. If we're paying household expenses out of a joint account, but what if one of us tends to book travel more often than the other one and tends to pay for that travel out of their separate account? Would that be looked upon as a gift, and should we instead be paying those bills out of our joint account?
Okay, do you want the strictly technical answer? No one's watching, right?
Nope.
The strictly technical answer is yes. If you take your spouse or your partner on a cruise and she doesn't pay for it, that's a gift. Okay? In the years that I've been doing this and had issues like this in similar, although not exactly the same context, but, the grandparents that take the whole family on the cruise or whatever it may be, the number of times that I've seen the IRS question something like this is zero. I've talked to colleagues. Number of times they've seen people question it is zero. Okay? So that's the strictly technical answer, is it's a gift. The practical answer,
Is it just a matter of transferring into one account to say, hey, it's been paid out of our joint account in such a situation like that, though?
Well, it's a little bit more than just paying it out of the joint account. Again, it goes to the idea of if one spouse is the one that's paying for the trip, even if it's coming out of a joint account, yeah, exactly. It's sort of tracing the source, I guess, is the way to say it. But again, of the universe of things that would keep one up at night, I would put that way down on the list.
And
that's my personal opinion, not the opinion of Vermont Freedom to Marry. Right?
That's right.
Okay.
And keep in mind, too, I didn't mean to scare you as far as with the compliance initiative around the real estate, but that's something that they can actually easily look into. There are town clerks all over the place that have public records that have everyone's deeds on there. That's something that they can do. It's a whole lot harder to look at your bank account and your bank statements. And I feel like we need to do another round. So let's move back to Brattleboro. Is there anybody in Brattleboro that has a question? We can take 2 questions from Brattleboro.
I have one.
Yep.
Just keep talking and we'll see you.
So, if you're married in Massachusetts, this is complicated, live in Vermont, and had a civil union in Vermont before the marriage was passed, do you need to get married in Vermont, or is a civil union automatically being considered marriage?
A civil union is not automatically considered marriage. You are still civil unioned in the state of Vermont, but with a civil union, you get all the same rights and benefits of marriage. So you get everything that Jess and I do as a married couple in Vermont, but you are called a civil union partner as opposed to a spouse.
So there's no reason legally to need to get married for a 4th time, really?
Presents.
Exactly, yes. Not right now, but we don't know what's going to happen when DOMA gets repealed, but there is a very good argument that when DOMA gets repealed, the only people that will be able to be treated as spouses are people who are in fact married. Not civil union, not registered domestic partners
We are
in
actually
California.
we are married in Massachusetts, so that would count.
So for you, it sounds like you're covered, but if the general question is there any legal benefit to get married when what we have right now is a civil union, that potentially will come up when DOMA is repealed. Other question in Brattleboro?
Yeah, yes. I've been supporting my partner for the past 2.5 years while she went through graduate school. She has not earned income in 2 years. I'm just wondering if we should have been doing something differently as far as, you know, is there any way or workaround for her as a dependent at all, or, yeah.
The way that you just described it, if she has no income, no income, then you should be able to claim her as a dependent. And again, there's a different rule for dependency versus whether you're considered single or head of household.
Okay. And I guess, yeah, that brings up the question. The accountant we've been working with, he was familiar with doing taxes for people with civil unions, but this was something that never came up or that he ever suggested to us. So we would then, you know, that kind of ties into the first question that was asked about finding, you know, someone who would know about this to work with. And I'm assuming that this list that you're compiling, there might be somebody that you recommend or not necessarily.
Well, so again, the list that we are compiling it's not a recommendation from Vermont Freedom to Marry. These are people we sent out an email to the folks that are on our email list saying, if you self-identify as an LGBT-friendly professional and would like to be included in this list, let us know. So we can't endorse anybody who is on that list.
Okay.
But it's people who've put themselves out there as LGBT-friendly professionals.
It might be worth checking the VT Gay Guide as well. I don't know if that still exists, but it used to have a compilation of that as well from the Samara Foundation. Do you know if VT Gay Guide still exists?
I actually found it online just yesterday, so I think it does. I don't know whether it's being maintained, and I feel a little self-serving because I was the only account listed there.
Let's hope it's not being
But, you know, it's fine the way it is. I think that RU12 may have taken over some of the Samara programs, and I don't know whether that's one of them or not.
Did everybody in the other locations hear what was just said?
Sorry.
No.
Okay. So I guess there's a VT Gay Guide run by the Samara Foundation. The suggestion was that that folks could look there, and then somebody else suggested that, yes, it's still there. I just looked it up. However, I don't know how current it is and well-maintained, and possibly RU12 possibly has taken over that as well. Where were you? Where'd we go? We move into did we take 2 questions in Brattleboro? Yes. We did. How about Montpelier? Is there anyone who has a question in Montpelier?
I do. So we are married in Massachusetts, and I'm just curious if Vermont, the benefits that same-sex couples have in Vermont by being married in Vermont are afforded to those of us who are married in Massachusetts, and if not, can we and or should we get married again in Vermont?
No, you're married in Mass. The thing about Vermont, the beautiful thing about Vermont is it didn't pass same-sex marriage. It passed marriage equality. It said any 2 consenting adults can get married. And so, generally speaking, a state will recognize any out-of-state marriage unless it flies in the face of its public policy, and it doesn't fly in the face of our public policy that you've married your wife. So you're married for purposes of Vermont law.
Thanks.
Sure. Somebody else in Montpelier?
I think we're passing on that.
Okay.
White River?
Yeah. White River Junction?
I wanted to speak to the question about advanced directives.
Okay.
I work in long-term care, and I wanted to recommend the Vermont Ethics Network as a great place to get more information on advanced directives and that kind of planning.
Thank you. And in fact, that is the link that is on your handout card. They're the ones that put out the form, and they also put out brochures. They put a wonderful brochure out that helps you really be thoughtful about the decisions that you make and gives you advice on on how to have discussions with your agents that you choose to make those medical decisions. So, thank you.
Okay, I was just handed the winning lotto numbers, so if you want to listen. It says, please remind people to face their microphones when speaking. Several people are not being heard because they're not right on the mic. So, thank you.
Anybody else on White River Junction?
No further questions
Okay.
from White River?
Oop.
Right, a late arrival? Didn't hear that. Go ahead, please.
No, I said there were no further questions from White River. We're all set.
Your witness.
Williston, back to you. Any questions in Williston?
Thank you. My name is John. I'm in a slightly different situation, I think, than most people here. My husband and I have been legally married for quite some time, but this is our first time living in a marriage equality state, so I guess I'm grateful to be, there's a lot of extra questions that I have as a result of that, but I'm grateful to, to have them at all. So, yes, thanks to everybody who, brought marriage equality to Vermont. We moved here during the year at different times because I accepted a job, but he had to finish his semester at school before moving out. Both of our employment situations changed. We were both working part-time when we were in Wisconsin, and now are full-time in Vermont, but got to that at different times after our move, et cetera, et cetera. So this may seem like a kind of an elemental question, but we've been using tax preparation software because living in a non-marriage equality state, it was very easy just filing singly on the state level and on the federal level. But because of the peculiarity and specificity of our situation, would it be advisable to see a tax professional, keeping in mind that, we're both young professionals, so we're just starting to pay our student loans back. We're just kind of trying to weigh the cost and benefit of going it alone versus seeing a financial professional for those, for our tax situation this year.
I'm going to recuse myself from answering that question.
Well,
say yes.
No, just use TurboTax.
Come out.
No, it's a really good idea to talk to a tax professional, even if you go just once. If you go 1 year and then you decide, whatever. But yes, you should go to the tax professional because, as Ken illustrated through his examples, there are a lot of things out there that TurboTax isn't going to think about, and frankly, a lot of accountants aren't going to think about unless they're really, really honed into the particular issues that same-sex couples face. I think it's very important to go see a tax professional in our situation. Anybody else in Williston? Ewan?
This question doesn't actually apply to me, but it might apply to people I know. Do you have any thoughts about guardianship versus second parent adoption? Can you use guardianship instead?
I can't scan the federal law in my head right now to see. No, I'm not being facetious. There are certain benefits that apply to somebody's child because they are their parent that they're not going to get as a guardian of a child. But I can't give you a specific example right now. I would say if you're going to spend the money to go to court to do one of them, do the adoption.
Thank you.
Sure. Back to Brattleboro. Any questions in Brattleboro?
I have a question. Before all these laws changed, Diane and I changed our name, so we have a shared last name. And is there any practical? I know that legally it gives us nothing, but do you see examples in situations where you might want to have an advantage that having the same last name is helpful?
I can name one.
Jace, tell us. Just speak into the mic.
Yeah, my husband and I are within 10 years of each other, and by taking my last name, if we go to another state, we become brothers. If we're in such a situation where we have to prove our relationship. And in such a situation like that, it's usually never questioned when both of your licenses say the same last name. So I would think in that situation it becomes an advantage. If you're, obviously, if there's a huge disparity, it wouldn't apply. But, I mean, unless you could say mom and dad had us that far apart. But.
So you're within 10, meaning you're 10 years apart, or you're pretty
we're 10
close?
years apart, but you
10
could look at us and say we're brothers. I mean,
Interesting.
We don't play it off like that. But.
Yeah, I have it.
That's our advantage.
Oh,
that's what
great.
we've found as an advantage in that.
Yeah, that's great.
I don't know if there's any other legal.
I can't think of any. I can't think of any legal advantage. But I will tell you this. Jess and I don't have the same last name, and when we were thinking about how to name our son, which last name our son was going to take, that I think that's a common discussion that some couples have, and what we decided was that he would take my name, since if either one of us was going to have to prove their parentage, it was going to be me, because I'm not biologically connected to him. But me being the paranoid lawyer that I am, ended up having us put her last name as one of his middle names. That way, at least on his passport, they can see Jess Olive and he's an Olive, and they can see Alexia Vanafra and he's a Vanafra. But that's me being paranoid. There's no law that supports what I'm saying. It's just what we decided to do personally. Is that our first question?
I think so.
Any other question in Brattleboro? No?
All right, we will go Montpelier. Go to Montpelier, please. No, we've got all the problems solved in Montpelier. All right, and that's good. White River.
Yeah, hello. This is Linda. I just want to go back to this issue of becoming siblings in another state. Why does that sound terribly illegal to me? I'm wondering if it seems to me that must be illegal, regardless of whether you have the same last name or not. My partner and I are routinely mistaken for each other. We could in fact probably easily be sisters and could fake it pretty well, but I can't imagine it's legal. So help me out here.
I just want to know, I don't endorse this question.
Well, it just so happens that if my husband weren't here, he wouldn't have endorsed me opening my mouth. So I only do so because he's not here. And I'm sure it's not illegal. I'm sure it's not legal to pretend you're someone you're not. But I'd like to. I don't know. I guess we've envisioned it in a hospital scenario where we're refused access to each other. And in such a situation where you're in a different state and someone says, prove you're who you are, if we have two licenses that share the same last name, that's easier than trying to negotiate, hey, we're married in a state that recognizes our marriage, and don't you want to recognize our marriage? Well, no, let's just not get into it. We're brothers. Can you prove that we're not? And let me in, is sort of what it's come down to.
Mm-hmm. Very interesting.
But yeah, if they called it out on the carpet, yeah, I mean, but lock me up.
It would be a misdemeanor.
Yeah, right.
Anybody else in White River?
I did want to add a comment. Hi, this is Diane. To the gentleman in Williston who is questioning whether he should pay the money for a CPA or do his own taxes. And although my CPA is in Williston right now, she did not pay me to say this, but I wholeheartedly agree that you should absolutely go to a CPA. My spouse is also a student, and we found significant financial advantages going to a CPA.
Thank you.
Thank you.
Thank you, Diane. Williston, we're back to Williston. Anybody have questions in Williston? We bored you to death? What? My list? What? Just wanted to make sure.
I have a question. Do I need to press the button first?
Nope.
No.
Okay. So for parental rights, in terms of a donor agreement, I am confused about if there's a known donor, kind of how they give up their parental rights in order for a second adoption to occur.
Part of the second adoption is to terminate the other parent's parental rights. So you send out the petition, you give him notice of the fact that you're going to adopt, and either they have a chance to show up in court, or if they don't care, which hopefully you've laid the groundwork so that they don't care, they can sign off on it. So that's how it would happen.
Great, thank you.
Just as a follow-up to that, I have friends in Massachusetts who are going for third parent adoption. They have a known donor, and so all three of them are going to get to be parents.
Wow. Very progressive.
What if it's an anonymous donor from a sperm bank?
Then he does not have parental rights to begin with.
Okay.
John?
Sorry, this is a question that I was asked to bring from somebody who couldn't be here.
Great.
He had entered into a civil union when he was living in New Jersey, but has moved back to Vermont, and that relationship has ended. So his question was civil unions, because the understanding is that Vermont recognizes his New Jersey civil union. Therefore, how could he dissolve that civil union now that he's in Vermont and not in the state where the civil union was entered into?
You actually raise a good question. A lot of people call me with a similar question, which is, I'm no longer in Vermont. I have a Vermont civil union. How can I dissolve it? So let me answer your question, and then I'll move back to this common one. Whether Vermont is going to recognize the New Jersey civil union is going to depend on looking at what a Vermont civil union, what the statute on Vermont civil unions looks like, and what the statute on New Jersey civil unions looks like, and if they confer, if they look enough the same that it smells the same, then he, after establishing residency in Vermont, you have to be a resident for at least 6 months before you can get a dissolution or a divorce in Vermont. Then he will be able to, and it's enough for one of the parties to be a resident in Vermont. It's not necessary that both parties be a resident. So if that's the case, then he will be able to dissolve it in Vermont. But it really depends on looking at the law and making sure that just because it's that it's not only named the same thing, but it actually is the same legal construct.
And how would he go about proving that, or would he need to have a legal professional examine it?
Yes, he would need to have. I'm sorry to cut you off.
Oh no, so then make their case in writing, or how would that work?
Yes, the first step would be to talk to a lawyer, to have the lawyer research the New Jersey law and compare it against Vermont law, and then give them advice on what to do. And if they're similar, then you would file a petition for dissolution in family court. And the lawyer might have to write a brief to the judge that basically says, hey, this is the same thing as a Vermont civil union, so you can give us a dissolution. The other question that I get calls every week on this from out of state, is I'm in a Vermont, we were so excited when Vermont had civil unions. We came up, we got civil union, and we went back to our states, and now it's been 5 years and we're not together anymore. What can we do? And the sad news is that there's not a whole lot that you can do. I mean, you have to, there are very few states that will recognize a civil union, and even marriage equality states, you really have to talk with a family law professional in that state and get them to do that same type of analysis that I was just suggesting, John, that a lawyer do for your New Jersey person. Because that, here's the pitch for universal marriage equality. The hodgepodge that we have in the United States right now is such a mess. It's such a legal mess. It's obviously such a it's a practical mess, and it's a personal mess. It affects our lives. But even as a lawyer, it is such a mess. There are registered domestic partners from California who come out here and try to get divorces, and that's a difficult question. There are people in Massachusetts that are trying to suggest that because they got a civil union in Vermont and then went off and married somebody else in Massachusetts, that's not bigamy because the civil union didn't count. It's a huge, huge mess, which is why we have a lot of work ahead of us.
Bill, on that?
Sure.
With the question about whether or not, and I hate to think I'm ignorant on this, when we got married, it wasn't clear to us if our civil union automatically became the marriage or if we now have a civil union in Vermont and a marriage in Vermont. And should we get a separation? Do we need to dissolve and divorce?
No, I mean, what the law says is that's interesting, because what the statute says is that the only people who can get married are folks who haven't been married before or haven't been civil unioned, unless you're marrying your civil union partner. There's the exception. But do you have a civil union and a marriage, or did it transfer into a marriage? That's a really good question.
Responding that way, because I'm like, it seemed like maybe it was so simple and I should have just seen it right on the form.
No, it's not. I don't know.
It won't happen, so we don't have to worry about it.
I don't know, but I know who I can ask. Susan Murray in my office, who fought for this whole marriage equality thing.
Remember her?
Hi, my name is Paul. I'd like to piggyback on that question, if I may. My partner and I, we've been together for 22 years. It's a border relationship. He's Canadian, Quebecois. We have a civil union here in Vermont. We celebrated that 5 years ago. We are now entertaining a marriage in Canada to protect our rights as a couple in Canada. Now I'm wondering how that would play, whether that marriage, that Canadian marriage, would be recognized in Vermont, a marriage equality state. If DOMA were to be repealed, would that marriage be recognized by the federal government? Should I pursue this marriage is what I guess I'm asking, because I'm repeatedly being asked the question by my partner, when are we going to do something about this? And it's a primary reason why I'm here tonight. So.
Well, I can't tell you whether you should get married or
I
not.
know. And that was unfair of me to ask you that.
I mean, it's an interesting question. Again, the general rule is that, and let's put all these states that have enacted these mini DOMAs that, say, we're not good, that it's against our public policy to recognize marriages between a man and or unless it's between a man and a woman. Typically speaking, the way our country works is that a state is going to recognize another marriage unless it flies in the face of its public policy. So I don't know what the Canadian law is, so I can't tell you this for certain. But from what I know, Canadians are all right. They're all right. They don't do crazy things, and I'm guessing that marriage in Canada is like marriage in Vermont. So unless there's some crazy thing about marriage in Canada that would upset our public policy, a Canadian marriage should be recognized in Vermont, especially because we have marriage equality and we recognize marriage amongst same-sex spouses. But I couldn't tell you that for certain without looking at Canadian law, which I don't know.
Okay, thank you very much.
Sure.
We're going to go to our questions now?
Yeah, where are our questions? Right here? We've actually covered some of them. Something, let me see, we talked about FAFSAs. I'm going to talk about that. We talked about that. I got an interesting question, which was, what are the benefits of marriage? And I'm going to cover the legal benefits of marriage. I'll let you all make your own decisions about what other personal, spiritual, and physical benefits there are. But some of the benefits, and I want to talk to you about some of the state benefits of marriage. In other words, the benefits that you get in the state of Vermont if you are a married couple or a civil union partnered couple. And these are just a couple. One thing is that your spouse or partner can't disinherit you. Okay, there's a forced share. If your spouse dies and they try to disinherit you, you're going to automatically get at least a cut of their property because the state's not going to let them do that. So that's one thing you get by being married or being a civil union. Another thing is the tenancy by the entirety benefit that I already talked to you about. Another thing is that you can sue in state court in state claims for loss of consortium. If your spouse is so injured that your relationship, your physical and or emotional relationship changes, you can have a claim for damages for money because of that loss, and that's only available to spouses and civil union partners. Same thing with a wrongful death claim. If your spouse is killed wrongfully, you can bring a suit, and you couldn't do that with a long-term partner. You could do that with your spouse or a civil union partner. Another thing is that spouses and CU partners can't be forced to testify against their spouse or CU partner.
Is that state only?
Well, it's state only because you're only recognized as a spouse. If you're in a federal court,
Does not apply.
you're not a spouse according to the federal court. You're not a spouse according to federal law. There's a presumption of parentage. Somebody is presumed to be the natural parent of a child if that child is born to the marriage or to the civil union, but you still need an adoption. And there are there's a state Family Leave Act that's like the federal Family Leave Act, and is actually sometimes more generous. So you are entitled to that. You get to file jointly on your state taxes, and there's some other things too. So those are some of the benefits that you do get. Maybe we can end on a high note. Those are some of the benefits that you do get at the state level for being in a marriage or in a civil union. So. Going once, going twice.
Can we ask from Brattleboro?
Well, I have a conclusion. I have a conclusion that I have to tell you about. Sure.
I'm in Brattleboro. So is there any, until DOMA is repealed, is there any benefit to pretend that we don't know, that the feds aren't going to recognize us as married, and to file our federal returns as married? Well, like, what are there penalties? What happens? It gets sent back. Are there going to be fines? Is it just good, civil disobedience? Or is it a bad idea?
I've been chomping at the bit all night to answer this question. Let me first say that a tax professional would not be able to assist you or sign your return as a professional. That is, if he or she wanted to continue as a tax professional. As far, and I've had this conversation with many clients, and the civil disobedience piece of it is, my opinion again, is very interesting, but let me answer your question without really answering your question. As I understand it, there are currently at least 2, and maybe more, but at least 2 cases winding their way through the courts in, I believe it's Massachusetts, through the, or under the auspices of GLAAD, the office in Boston, on this very issue. Where it will come down, I don't know. And the advice that I gave my client, it wasn't even advice, it was the conversation that I have with my clients is, do you want to be the name on the case? And if you do, then go for it. I would imagine that there would be a number of professionals that would be very happy to assist you to make sure that the way that you went about it was a allowing you to minimize whatever potential penalties there would be. Okay? Meaning that the penalties on the federal side are based typically on not having paid enough tax. So, just theoretically speaking, if you made sure that you paid enough tax, and again, how you do this is a subject for a whole other discussion, but if you paid enough tax, then theoretically the penalties would be nothing. But again, I'm not advocating doing that. I'm not recommending doing that. I'm just saying that if it were something that one were interested in pursuing, that one should probably contact the folks at GLAAD and get some really good guidance because they're already doing it. Is that
Thank
a
you.
fair answer?
Colleen, did you?
Sometimes it turns out when we do that calculation, you know, where would you be if you were filing jointly? Sometimes it turns out that you're really better off not filing jointly. And I've read there's a website of, you know, people who are advocating that this type of civil disobedience, and some of them are saying that what you need to do is to file your tax return the regular legal way and then file an amended return, filing jointly, because then that really puts the it puts the IRS on notice that that's what you're doing. You know, you don't just sort of by happenstance not be noticed. You know, it really makes a statement, and that it would sort of kind of force the question.
Thank you. Any other questions? We have about 10 minutes. We're going to have to clear out some rooms.
I have a question, actually. When you were talking about the gift stuff and deeds and all of that, what if somebody does one of those quick deeds where it's like, you know, you see it all the time, families sell the house to their son for $1, you know, and so the only gift is $1, you know? Or is it the value?
It's the value. So the way a gift is anything that you get for less than what its fair market value would be. Okay, so if you get a house that's worth $300,000 and you've only paid $50, then you owe the rest, the 200 and whatever. Mm-hmm. I'm usually very great at math.
Would be a gift.
That would be, the extra would be a gift. So just because you pay something is not enough. You have to pay for the value of the house.
But shouldn't you also point out that there's a lifetime exclusion for gifts also? So in that situation, if that was the only gift, there might not actually be any tax involved.
That's right. Reporting would be required. Yeah, reporting would be required. You would have to report it to the IRS. Whether you end up owing gift taxes or not depends on how many gifts you've given over your lifetime, and they figure it out at death. And what your tax-free amount will be at death, we don't know at this point.
But that actually goes back to the issue that we talked about, where this year there is an opportunity to do it. I mean, the exclusion amount or the exemption amount for this year is over $5 million, just over $5 million. So if one were to be interested in pursuing something like that, this would be the year to do it. So we don't know what's going to happen come January 1, 2013.
That's right.
On the gift side, or on the amount side. Yes.
This is a great year to transfer property. That's right.
Robin?
I have a follow-up question. Maybe that doesn't apply. I guess I was thinking, is it considered a gift just the first year, or is it the gift that keeps on giving because of the value of the house?
It's when the transfer is made.
When the transfer is made. Okay.
Anybody else?
I have a question about Pillar.
Okay, speak. Okay.
If DOMA is overturned, and I'm wondering about gifts that were made prior to the period of time that DOMA's overturned, is there any discussion as to what may happen with that?
No,
so will the
I
gifts,
mean,
will the gifts just be from the time that DOMA is overturned, or will, if you've been married for 10 years or 2 years or whatever the period is before that, is it the time from you were married?
I am sure that once we overturn DOMA, those of us who do this type of litigation will be twiddling our thumbs and will be looking for stuff to do. People like GLAAD and other organizations that do this type of constitutional litigation, that's going to be the next frontier. I've even had people suggest that if you lose your spouse, that you apply for Social Security survivor benefits and you get denied, and you keep that denial letter, because who knows whether once we overturn DOMA, we can come back and have a claim for reimbursement for those benefits. So that's the next frontier, is once we repeal DOMA, is to see whether there's any kind of retroactive benefits that we can get.
Okay, thanks.
Was there another question?
Yeah, I had a question in Montpelier. Hypothetically, if you were to transfer your deed years ago, how would you claim that on your taxes? Like you're saying this year would be the year to do a deed transfer, but what if it was done before that? Would you have to go back and amend those taxes to claim that transfer?
Well,
or report it, I guess.
Yeah, let me just clarify, and if I'm not answering the question, let me know. So if I'm understanding you correctly, what you're talking about is the transfer of the home,
Yes.
the signing over the deed. Okay. So that is a gift tax issue. All right. So that would go to the time that it was done. All right. So if you, and just hypothetically again speaking, say it was a $300,000 house and you gifted it over, so there'd be a $150,000 gift that should have been reported, back in 2006 or whatever it was. There's no income tax implication of that. There is just the fact that you should have reported the gift, and as long as you haven't subsequently made gifts that exceed the exemption amount, the $5 million that we're talking about for this year, and the prior years it was different amounts. But as long as that hasn't been an issue, other than being delinquent in your filing, there's not going to be any tax ramification or money that's going to have to be outlaid. Does that answer the question?
Yeah, it just puts the feds on notice that I've transferred, that I've applied that to my $5 million that I get.
Well, again, it would go back to at the time that you transferred it, what was available at that time. So if let's just say it was $1 million and it was a $100,000 value that you transferred, you'd have $900,000 left. But you're absolutely right that now that it's $5 million, you'd have, and again, I'm rounding, it's $5,120,000 for those precise people out there. So for 2012, you could give, if you've already given $100,000 over and above the annual exclusion amount, you could give $5,120,000 less the $100,000. Does that clarify?
Yeah, that did.
Awesome.
Thank you.
All right.
So I'm actually going to wrap it up because I think we do need to have some time to file out of here. So I just wanted to say thank you so much for coming tonight. You should congratulate yourselves for coming out on such a blustery winter night and thinking about topics that, while not the most entertaining or sexiest topics in the world, are really crucial to protecting yourselves and your family. So here's my plug. You've gotten the ball rolling. Don't stop now. Do some more research on these issues. And one good place to start, Devin, if we could have the overhead, please, is there's a book put out by Nolo Press that's called Making It Legal, A Guide to Same-Sex Marriage, Domestic Partnerships, and Civil Unions. So that's a good place to start. It's going to talk about a lot of the things that you heard tonight. You'll see it in writing, and it's just another good way to kind of know what you don't know. Also, you can talk to an attorney and or an accountant depending on what your particular issues are. You have mine and Ken's information on those takeaway cards. We're also going to put it up on the screen in a minute. or if you already have an attorney or an accountant, give them a call. But as we've said, please make sure that that person knows about these issues as they are faced by same-sex couples, because as you've heard tonight, things are different for us. So just keep that in mind. And finally, I just wanted to thank everybody who who came out and everybody who made tonight possible. First and foremost, I want to thank Ken for co-presenting with me. I also want to thank Vermont Interactive Television for letting us be in 4 places at once. That's pretty groovy. Our greeters at each location, and my tireless and dedicated colleagues on the Vermont Freedom to Marry board. We are an all-volunteer board, and we are an all-volunteer organization. So everything that you've heard, seen, experienced, and eaten tonight, it was because of somebody's generous donation. And we're going to keep fighting. As you've heard tonight, we have a lot of work to do, and we're going to keep working, but we can't do it without your support. So please consider making a donation to Vermont Freedom to Marry. You can do it tonight through your greeter at each location, or you can go to our website and make a donation. You can get the information for making a donation there. Also, you can get on our email list if you haven't gotten on our email list, and our greeters can take that information. And you can follow us on Facebook, or like us on Facebook and follow us on Twitter, so that you can get the latest LGBT news. So thank you so much for coming out. We could grab the overhead one more time. Thank you.